SJC-13783, Commonwealth versus Stephen Pina.
Okay, Attorney McLean.
Good morning, may it please the court. Ian McLean on behalf of the Commonwealth, and I'd like to acknowledge Rosetta Lewis, the sister of the murdered victim, Keith Robinson, observing the argument today. The motion judge here committed a series of legal errors when he allowed this motion for new trial, the third motion for new trial, over a trial that he did not preside over. Beginning with the first issue, the post-it note in the treatment records, he committed a series of errors on that issue. First, whether the defendants could have obtained the treatment records at all. Second, if they had obtained the treatment records, finding there was impeachment value in there was none. Third, in the proffered experts that the defendants utilized, they would never have been allowed to testify at trial based on their credentials and their background. And then fourth, in his analysis of prejudice as a result of not having these treatment records, and that he failed to grapple with the strength of the Commonwealth's case at all. So starting with the first error, obtaining the treatment records. This trial was in the 90s. So whether or not the defendant could have obtained the treatment records would not be analyzed under the Dwyer Protocol, which came into existence in 2006. It would have been under the Bishop Protocol that existed as of 1993. What they offered here at the motion for new trial doesn't even come close to clearing the Bishop Protocol. All that they offered here was the mere fact that there were treatment records.
I was around during that period of time and utilized Bishop Fuller. And it seems to me that when you have information like that under the Bishop Protocol, it would go to the judge, correct?
That's the first step of the Bishop Protocol.
And the judge would make and that was the fallacy of Bishop, that the judge would have to step in the shoes of the defense attorney. But that's what Bishop and Fuller required. Where you have an important witness, or the most important witness, and the information is that the witness is under psychiatric care, you don't think that a judge would say, this requires me to look at these records?
It might under Dwyer, but the initial step of the Bishop Protocol required a showing by the defendant. And that showing was, at a minimum, a likelihood that the records contain relevant evidence to justify judicial review.
Correct.
Then a few years later.
It strikes me that a judge who has a witness who has psychiatric issues, and it always would then raise the issue of the ability of the witness to perceive, remember, recall, and the witness's impairments, that would satisfy that standard.
Well, I completely disagree with you, Your Honor. I mean, seasonal affective disorder is a mental health condition, and that has nothing to do with a witness's ability to perceive, recall events, or be a witness at all. The Bishop Protocol, the way it existed at the time, said the likelihood that the records will. And then,
so you think, if you think a Superior Court judge going back in the 90s has a post-it note and says that this witness, who's the most important witness in the case, is under psychiatric care and is in fact committed to Taunton State Hospital, well, it could be a cold or seasonal affective disorder, so I don't have to look at it? That's
exactly what the court said in Bourgeois in 2007. Mere existence of records does not meet the initial burden to go to the judge. So the first error—
Is that witness the key witness in the case?
I believe that was the victim themselves, Your Honor, in Bourgeois.
Okay.
So the judge here failed to even acknowledge the existence of the Bishop Fuller Protocol. It's not even in his memorandum and order on the motion for new trial. So he didn't even grapple with it. He just said, they get them. So that was an error of law. He didn't even apply the controlling law to the relevant question. So absolutely an error of law. But even if you're going to say that was not an error of law, and you're going to say they would have gotten the treatment records for an in-camera review, then we turn to look at the content of the treatment records themselves. And this leads to his second error, saying that they contained impeachment material. They simply did not. To begin with, he made no factual findings at all to support a conclusion that they contained impeachment material. Zero factual findings. The mere existence of a mental health condition does not mean it provides a line of meaningful cross-examination to impeach that witness.
What about the fact that she was hospitalized at the time she testified? That's not a line of impeachment?
The mere fact that you're hospitalized is not, Your Honor. You have to look at the symptoms of what you're hospitalized for. You could have been hospitalized for a heart condition, and that doesn't provide a meaningful basis for it.
So then, she's suicidal, I thought.
Yes, she was suicidal. She was in custody for an unrelated case, and she made suicidal ideations and was refusing to eat at the time.
So sticking with that fact, answer Justice Wolahojan's question.
I don't see how someone engaging in suicidal ideations means that they are, how does that provide a line to challenge their truthfulness, their ability to perceive events, or their memory? Those are the three things that we talk about when we're impeaching a witness.
Well, you started off by listing all of the issues that you have, at least with this particular, the psychiatric records, and you dismissed the two people that the defendant called for expert witnesses. Didn't those two doctors testify that at the time this witness was suffering from borderline personality disorder and antisocial personality disorder?
Well, first off, Your Honor, that's not accurate. What the witness was diagnosed with was personality disorder with borderline and antisocial features. That specifically means she does not meet the diagnostic criteria for borderline or antisocial. It means she has some of the features, some of the symptoms of the conditions.
Granted, it might not be line up directly, but both of those witnesses also then tethered those diagnoses to a witness's ability to perceive.
Well, all right, let's start with Dr. Franklin then, Your Honor. Dr. Franklin admitted that her opinions about antisocial personality disorder were speculation. Her words, speculation. That's at volume 1, page 121 to 122. And that those opinions have zero support in the academic studies. There's no value there. So that witness never diagnosed or treated a patient, never even interacted with a person with borderline personality disorder, never met Annis, never tested her memory, never looked at any brain images of her to show that her brain was malfunctioning in some way.
So the burden you have is that Judge Krupp had a hearing, and now you have to discount these expert witnesses as clearly erroneous, correct?
Yes, well,
His finding is
so yes, if he had made any factual findings, but the point is he didn't make any factual findings about how any of these medical situations would have pertained to her ability to be a witness. And the fact that you have a mental health condition is not relevant. It is the symptoms of that mental health condition, and it only becomes relevant if they affect your ability to be a witness, which means truthfulness, perception, or memory. That's not the case here. Borderline personality disorder, the symptoms are mood instability and behavioral disruptions. That has nothing to do.
I understand that you disagree, but if we marry this with Justice Gaziano's point, you don't have in the record that Judge Krupp discredited the witnesses that were produced by the defendant as part of the motion. These two doctors, Dr. Franklin or Dr. is it Kleonsky?
That's my understanding.
Okay. You don't have in the record that he discredited these two folks.
Not that he discredited them, but he didn't make any affirmative factual findings that would justify a legal conclusion that there was any impeachment value.
So leave us again, assuming that you disagree with this, it's not a reasonable inference that he credited their testimony, even though there's the concern about whether or not it might meet a Dober-Lanigan burden at trial for purposes of a motion for a new trial. He's not able to credit the fact that this doctor said, hey, this might affect her ability to perceive and memory.
If he had expressly written, I credit this witness, I would agree with you. He did not do that here, and he made zero relevant factual findings. If you want to infer that he credited the witness, that means he credited Franklin saying, my opinions are speculation and there's zero support in the academic studies for them.
Sure.
I don't see how that could support the legal.
Because he's also the fact finder, right? So he's not only just acting as the judge making the legal conclusions, he's acting as the fact finder. And the fact finder, we tell juries all the time, you can credit some of the things that a witness says, other things a witness says, or you can discredit all the things that a witness has said. So can't we just, is that a reasonable inference that for this purpose of this issue, that he credited that if the defendant had this information, that it would have given him at least impeachment value that might have swayed the only key eyewitness for the government in this case?
No, it is not, Your Honor, because the witness says contradictory things. So if you credit the witness's testimony, implicitly all of it, you've credited two contradictory things. This witness is saying, my opinion is X, and my opinion X is based on my speculation. So if you say I credit the witness, what are you crediting? X, or that it's speculation? So the judge here had an obligation to actually find relevant facts that would have established any of these potential medical conditions actually bore on her ability to be a witness. He did not do so. Legal error. Now, even if you were to say that he hadn't committed a second legal error there, then we go to the third question, whether these witnesses would be allowed to testify. They would not. I've already gone through some of Franklin's admissions about things. Then if you look at the other witness, Kleonsky, she also admitted that she never met Annis. She never reviewed any brain images. She acknowledged that the medical records showed nothing about hallucinations, memory loss, confusion, or disorientation. She admits she never even reviewed the 18A report from the doctor that treated Annis while she was at Taunton Hospital. So she never met with them. She never even looked at the documents from the doctors that did meet with her. And then she also went so far as to say Annis was clearly having a psychotic episode when she observed this murder take place in front of her. Her basis for the psychotic episode was that she found her testimony of what she saw to be so outlandish and so improbable. If you read the testimony of the officer that responded, the first responder, what their description of what they did is almost exactly what Annis said she saw. And now this expert is saying that equates to a psychotic episode. It's simply not a psychotic episode. Her opinion is worth nothing. So these witnesses would not have even been allowed to testify at a trial.
Ask you a basic factual or foundational question.
Sure.
If the evidence that you adduce in terms of prosecuting your motion for a new trial, does that mean that's the only people that the defendant could call at the time of trial?
No, it certainly doesn't. But, Your Honor, the defendant, when filing a motion for a new trial, has the obligation to establish any facts outside of the record. Here, what they proffered is not admissible, so they established no facts. So there's no basis on which to allow the motion for a new trial. It's a fundamental misunderstanding by the motion judge about his role in evaluating a motion for a new trial. He doesn't get to speculate about things. He has to see what the defendant proved and if that meets their burden. Any facts outside of the record the defendant has to prove. Here, their experts would not have been allowed to testify at a trial. They proved nothing.
Well, I guess it goes also to the issue of the Brady violation. So is the Commonwealth contending that, again, at the time of a motion for a new trial, that the showing that the defendant has to make has to also meet the evidentiary standard at trial? I don't, and if you're contending that, what's your legal support for that?
Well, so, Your Honor, I point you to Barry. The defendant has to establish that the thing was in the prosecutor's care, custody, or control, that it was not produced, that it was in fact exculpatory, and that the resulting prejudice existed. The defendant has to prove all of those things in order to validate the finding of an error that then potentially could lead to the allowance of a motion for a new trial. So here, they didn't clear the exculpatory hurdle because, as I said before, they never should have gotten the records in the first place. If they did get the records...
Assume that we don't agree with you that it's exculpatory. I mean, I take it if you had a prosecutor call you from the trial division and said, hey, I have a Post-it note that says the key witness is in Bridgewater State Hospital. Should I turn it over? I assume that you would say, yes, you do.
Today, absolutely,
Yes.
I would say that, yes.
All right.
But
So say we disagree with you on whether it's exculpatory. Go to prejudice. Because it seems to me that was in what you just ticked off, the defendant has shown, but prejudice is the issue for me.
Well, so when you reach the prejudice question here, the motion judge erred by failing to actually grapple with the strength of the Commonwealth's case. Under Pope, when you're dealing with the impact of purported impeachment material, you have to measure that impeachment material against the strength of the Commonwealth's case. And here he failed to do that at all. He basically just, the quote from his memorandum is there was not a mountain of other evidence.
The
He
judge,
didn't ever even address the fact that there was an entirely separate percipient witness that identified the defendant as the shooter in both the photographic array and at trial. He didn't even address that. He also failed to even address the defendant's admission about 2 weeks later, a veiled admission to an officer.
The other witness was, I can't remember, she's a stranger witness or?
It was a man, right?
Hall is his name.
Yeah,
yes, a male witness.
Timothy Hall, I think.
I'm sorry, Your Honor?
I thought it was Timothy Hall.
I don't remember his first name, Your Honor. Mr. Hall.
But that identification, wasn't there a significant difference in what Hall said as to the size of who he perceived versus the size of the defendant?
There were slight differences, but
Right.
I would be more concerned if two witnesses described the person exactly to a T the same way. That there are slight differences is really to me
No,
no consequence.
but slight differences. He described whoever it is that Mr. Hall said he saw, he described them as being almost 270 pounds, right?
He also described the person that walked up rapping a song, and he described almost the same lyrics that Annis described.
Yeah.
And they had the same flight path away post-murder, which is where the murder weapon was actually found.
That just confirms that there was a murder. It doesn't really confirm that this defendant did it.
What we have here is two separate witnesses that both in a photographic array said, that's the shooter, and then came into court at trial and said,
to be
that's the shooter.
fair and honest, Hall said 6 out of 10, maybe.
at the time of the identification.
So the point that we're trying to make here is that the motion judge, whether the motion judge committed a legal error in his evaluation of what was before him, he didn't even grapple with the existence of Hall, didn't even mention him, just said there wasn't any other evidence. Failed to even.
For me, I appreciate your argument on this point, but it wasn't, as I read the judge's decision, the linchpin of the reason why he allowed the motion for new trial. He didn't just peg it to this, the non-disclosure of the hospitalization and the resulting prejudice of not being able to pursue discovery of the medical records. There were other bases too, right? So, and that's the context that I think we look at, because the judge was looking at a series of things. And he says that the third-party culprit newly discovered evidence was even more compelling, which seems to me to indicate that he prioritized that information over this component that you're focusing on. Do you want to talk about that?
Absolutely.
Like how can we disregard the judge's explanation and suddenly focus just on whether there was an error regarding the non-disclosure of information concerning the precipient witness?
So I'm happy to turn to I see that my time has expired, but I'm happy to turn to the incident report about the motor vehicle very briefly. The question there is, their claim was, again, a claim of Brady violation of a non-disclosure of two documents, the incident report about a stolen vehicle and then the stolen motor vehicle discovery form. So the only documents that are relevant here, you can find them at the appendix at 285, 286, and 287. That's what we're talking about, the incident report. So in order for there to be any third-party culprit evidence there, first of all, he said it was not a Brady violation until we have evaluated as newly discovered evidence. So that's the lens we're looking at it through. But in order for that to provide any third-party culprit evidence at all, there has to be a substantial connecting link to the case. The problem is, you look at only those documents, two documents, there is no substantial connecting link. The incident report, the victim came and said, I was carjacked at 10 p.m. of my car, a four-door red Nissan at, I forget the exact street address, 31 Horden Way in Mission Hills, about 2 miles from where the murder occurred, at 10 o'clock at night.
If the timing is wrong, then this starts to become more problematic, right? Because the gun is, the murder weapon is found with one of the people, right? That seemed to be the most troubling part of that, right? The murder weapon is found with whom?
The murder weapon was abandoned near the murder scene.
Right, and it's found with the person who's associated with that report, right?
Yes, but that's not the basis of the claim here. The basis of the claim is newly discovered evidence in the form of the stolen motor vehicle report.
We don't look at it in isolation, right? I mean, we look at it in the context of what the defendant knew and what value it added to the defendant's knowledge.
I completely disagree, Your Honor. The question here is whether these two documents constitute newly discovered evidence to warrant a new trial or not. They don't. There's no substantial connecting link here. Their claim was that stolen vehicle is the vehicle the murderer drove up to the murder scene in. That can't be the case if the vehicle was stolen an hour after the murder happened. Now, as to the position or the argument that there's...
Right, but it could be the case if there's an error in the report as to the time.
Well, of course, and two things that are
So
responsible.
and then the plausibility of that is something that the judge evaluated. So it's not like the judge disregarded that point. The judge took a look at it and said, let me test this. Is there a possibility that the time was incorrect?
Yes, he did, and that was an error. The defendant's obligation is to prove facts. It's not the judge's role to speculate about possible facts. There was no proof that there was an error in the reported time. The incident report where the victim comes in and says, I was carjacked, he reported it at 10:40 and said it happened at 10 o'clock. That's Commonwealth's Appendix, page 283. That's the best report of the time. Now, the discrepancy that we're talking about here is in another form that an officer wrote down about a stolen vehicle, where it was lost and then where it's ultimately recovered. There they wrote down that the carjacking occurred at 9:30 p.m. That was an officer writing that down. The evidence of when the car was stolen is 10 o'clock that came from the victim of the carjacking. Now, this argument about there was some confusion about it or something, or the victim didn't speak English well or something, that's wild speculation. It comes from, you can see the document at page 286 of the appendix. a note that was taken 2 years later on a phone call, where a person who received a phone call said, "I struggled to understand what he was saying." That has no bearing on whether the victim was able to communicate to the officer when he reported the car as stolen and that it was carjacked. It's wild speculation. It's not the motion judge's role to speculate about the world of possible evidence. It's the motion judge's role to evaluate what was presented at the motion for new trial and find facts. You can't then allow a motion for new trial about speculated other facts. The defendant did not establish that this car was stolen before the murder so that it could have been the vehicle that the murderers drove to the scene in, because the car was stolen an hour after the murder. No substantial links, no basis for it to be admitted at trial, no basis for third-party culprit evidence, no basis to allow a motion for new trial.
How about the DNA?
So
That's a problem.
I respectfully disagree, Your Honor. I mean, the motion judge himself said this is not enough to allow a motion for new trial. He said it's the absence of evidence. So
Right.
if you wanted to accept his findings on it, then that's what you have to accept.
Well, I mean, he did this on a confluence kind of analysis in any event, but you're saying the other factors that went in with this absence wasn't enough.
Absolutely, absolutely. And I just want to be very clear that the evidentiary hearing was limited in scope, and the DNA claims were not part of the evidentiary hearing. And it's legal error to allow a motion for new trial in the absence of an evidentiary hearing. And that's what, on this, to the extent that he argued it contributed at all into this confluence, that's legal error. They didn't put any witnesses on. There was no evidentiary hearing. The hearing was limited in scope.
But you guys agreed to that.
What was agreed before the hearing was they would let a couple of documents in.
Right, but you agreed that we didn't need an evidentiary hearing. Didn't the judge say, "I'm inclined to do this on the papers," and both sides agreed that that was okay?
I disagree with that characterization of the record, Your Honor, and I just point the court back to Compiano from 1995, that it is an error to allow a motion for new trial without
What part
a
do you
hearing.
disagree, though? What part do you disagree with?
That the Commonwealth agreed that there was a substantial issue raised in the DNA, and that
No, I'm talking about the fact that there was no evidentiary component to the DNA consideration, that the Commonwealth agreed with the way the judge proposed to hold that part with no evidentiary component other than the documents.
Your Honor, I don't have much more to say than I disagree with that characterization of what the Commonwealth's position.
What part of that do you disagree with?
That the Commonwealth didn't concede that there was a substantial issue in the DNA.
They did say that they didn't need an evidentiary hearing to go over that.
There has to be an evidentiary hearing.
You agreed to do it on the papers. There was the report and then the report that you submitted. You did not at any point, the Commonwealth did not at any point inform the judge that it wanted an evidentiary hearing with respect to the DNA test results.
Well, I'll acknowledge that, and I'll acknowledge that the
Okay.
exhibits came in under agreement. So I'll acknowledge that.
Okay.
But I would just point the court back just very briefly to the judge's conclusion that the DNA material did not warrant a new trial. So thank you, Your Honor.
Thank you. Okay, Attorney Tessier.
Good morning, and may it please the court. Jill Tessier, with me at counsel table is attorney Lisa Kavanaugh, on behalf of Stephen Pina, who is present here today. Mr. Pina was released from prison 4 years ago as of March 9th, after serving 28 years on this wrongful conviction. The only issue before this court is whether the motion judge abused his discretion in finding that justice was not done when the jury was deprived of hearing compelling evidence pointing to Brian Johnson and Anthony Woods as third-party culprits. Modern eyewitness identification science undermining the reliability of the identifications made by both Annis and Hall. Expert testimony showing that a key witness, Annis, suffered from long-standing psychiatric and a psychiatric illness and substance use issues that likely impaired her ability to accurately perceive, recall, and reliably identify the perpetrator, and modern DNA analysis excluding Mr. Pina from relevant areas of the murder weapon and the victim's clothing. Judge Krupp's careful, well-reasoned decision falls well within the range of reasonable alternatives, and there is no basis to disturb it. Judge Krupp's decision should be affirmed on the third-party culprit issue alone. We now have compelling, substantial connecting links that demonstrate that Mr. Pina was deprived of a significant third-party culprit in Bowdoin defenses that would have been real factors in the jury's deliberations. The jury did not hear that Brian Johnson, a person who stole the murder weapon from his father in the weeks leading up to the murder, bore a scar in the same location as a bleeding wound observed on one of the Annunciation Road robbery victims who refused medical attention or police help and said to the police, "Don't worry, I'll take care of it myself," mere hours before the murder. The jury did not hear that Johnson and Anthony Woods, a person who fit the description of the shooter, were arrested 2 weeks after the murder in a vehicle that was stolen at gunpoint on the night of the murder and that matched descriptions of the shooter's car. As the Commonwealth previously asserted and the motion judge found, it defies logic that these are mere coincidences. And defense counsel was on to something on this end, but he lacked the evidence necessary to tie it all together for the jury. Evidence that would have supported an argument to the jury that a person who stole the gun before the murder was also the victim of the Annunciation Road robbery, that the Annunciation Road robber was Keith Robinson, that the person who stole the gun was arrested 2 weeks later in a car that matched the description of that used in the shooting with a person who matched the description of the shooter. All the jury heard at trial was that the Annunciation Road robber and Robinson were both wearing red-colored jackets, that the description of the Annunciation Road robber was close to that of Robinson's appearance, and that housing officers had initially suspected a link between the two incidents, but by the time of trial had completely disavowed this. The prosecutor on the other hand, argued vigorously to the jury that there was no connection between the two incidents and that the red jacket had absolutely nothing to do with the murder. Counsel also tried to get in evidence through cross-examination of Detective McCarthy, evidence regarding Robert Grady, the owner of the gun, his son Brian Johnson, who stole the gun before the murder, in order to show that the police never thoroughly investigated Johnson's connection to the gun. But the Commonwealth moved to strike, the judge agreed, and the jury heard none of this. And even though Judge Krupp analyzed this as newly discovered evidence, all of this is set upon the backdrop of what we know now, that the Commonwealth itself had some reason to suspect something about Johnson and Woods because there were 25 pages about both of them contained within the trial prosecutor's trial file, tracking the progress of their cases related to the arrest in the maroon Nissan. The Boston Police homicide file had their arrest reports in their file for this very murder.
So the difficult part of this case is that Judge Krupp, there wasn't any single thing that was dispositive here. He's doing this kind of cumulative analysis under Rule 30, and so that makes it really hard to kind of just parse this out and say which one's weighted which way. So let's just focus on the car. How do you respond to the Commonwealth's argument about the timeliness issue? Because the best evidence, and I'm not using it in an evidentiary sense, I'm just saying the best evidence of when that car was stolen was the own first-party report of the person whose car got carjacked. And that person puts that carjacking before the time of the murder.
Sure, Your Honor, I'd be happy to address that. So I think it's first important to note that the carjacking victim, Mr. Thelesmond, did not report the carjacking to the police until the following morning. So it was actually not 10:40 p.m. that night, it was 10:40 the following day. And of course, as Justice Wolahojian acknowledged, there could be errors in transcribing the reports. And in fact, the reports were internally inconsistent. One said 10 p.m., one said 9:30. But the fact of the matter is that there was no concurrent external record of when the carjacking occurred because Mr. Thelesmond did not call the police. So we don't have a 911 tape to verify when the vehicle was stolen. We don't have a CAD sheet or any sort of dispatch log to tell us more reliably when the vehicle was stolen. And I think the greater point of all of this is that you have to consider the issue of when the car was stolen in the context of all of the substantial connecting links. And that goes to the weight of the evidence, not the admissibility. So the Commonwealth could argue whatever inference they want the jury to draw from the timestamp notations, but the problem is the jury didn't hear any of this, and that's where the real issue lies.
You talk about the psychiatric records.
Sure.
In light of all of the kind of warts to them, how would the psychiatric records have been used at trial?
Sure. So this court has long held that evidence relating to a person's substance use or mental health is admissible as impeachment evidence as long as there's a link between that and the person's ability to accurately perceive and recall and testify. At the time of trial, Mr. Pina would have consulted with an expert like he did here with Dr. Kleonsky, who would have been able to explain to the jury how her long history of substance use disorder, which dated back to her adolescence, and her diagnosis of borderline personality disorder, how studies support that those diagnoses fundamentally alter the cellular makeup of the brain. And she went into great detail explaining how each of those diagnoses affects different parts of the brain in ways that I'm not qualified to.
Is it Kleonsky or Franklin who says that there's no peer support for their conclusion?
That's not what they said.
Okay, well,
Dr. Franklin said.
the one that has the problem.
Sure. So Dr. Kleonsky is the psychiatrist who testified about the records from a medical perspective. Dr. Franklin testified from the perspective of an eyewitness identification expert. And she testified about her review of studies of relating to people who are known to have borderline personality disorder and the impacts of that disease on cognition and memory, which is in her field of cognitive psychology. So she testified about a subset of her field, which is eyewitness identification evidence. And she testified that the factors that this court has generally accepted, the studies assess them using a baseline typical person, right? Because it would be difficult to just pick particular people who have certain diagnoses in order to conduct these laboratory tests. And that the hallmarks of borderline personality disorder, as she understands them from the research that's conducted on them from her field, is that one of the hallmarks is this increased stress response for people who have borderline personality disorder. And she talked about how this would essentially enhance the effects of the underlying estimator variables of stress and potentially weapons focus, because those are really assessed on typical people with no mental health or substance use conditions. And we know that stress is a huge factor, and that's counterintuitive.
That's conflating the new science of eyewitness testimony with this, which didn't exist back then, right?
Sure.
So let me ask you, how was the witness impeached at trial?
How did it actually happen at trial?
Right.
So defense counsel cross-examined her on her inconsistent statements, which she made several. Her statements were inconsistent as to her memory and observations of the immediate aftermath of the event. So for example, she told the jury that she went and remained by Mr. Robinson's side until he was loaded into the ambulance, yet first responders testified that they never saw her there and that she wouldn't have been allowed within that perimeter because they cordoned off the area.
What about her substance use?
In terms of her substance use, well, this is part of the problem, Your Honor. Defense counsel tried in earnest to cross-examine Ms. Annis on her substance use history, which he proffered to the judge would go directly to her ability to accurately perceive and recall events. But as to every single question, the prosecutor objected, and the judge agreed. And the only thing that counsel was able to ask about was whether she was using drugs on the night of the murder and whether she was using drugs on the night of the identification procedure. So that's fundamentally different than what the jury would be able to hear now, knowing what we know about her.
Right. So then that leads to the inquiry of the case law that we have that says that mere impeachment evidence, usually the discovery of impeachment evidence, usually isn't enough to sustain a motion for new trial. How do you address those cases?
Well, the court has never held a broad prohibition against the use of impeachment evidence being warranted in a new trial.
We usually have to say it's blockbuster impeachment. I mean, I forget the name of the case, but you probably remember it. Justice Link wrote it, but anyway.
Well, sure. So I think here we have a witness who is the primary witness at trial. So the jury believing her is a really important piece of what happens with the verdict. And in fact, the SJC decision, the entire fact section is framed on Annis's testimony. So we know her testimony was important. She's an eyewitness. There's no physical or forensic evidence connecting Mr. Pina to the crime. So that makes her testimony even more important. So discrediting her was pivotal, was critical to Mr. Pina's defense. There was no other way for him to mount a defense in this case other than, presenting a third-party culprit defense in order to challenge her identification and her reliability as a witness. So I think this is one of those blockbuster things when a conviction is based primarily on her testimony.
Is it though? Because in the universe of impeachment devices, the one that was used actually at trial was a prior inconsistent statement. So it's not character, but you get to argue that this witness has said different things at different times about something that's really important versus the speculation that this person there's a theoretical person who, if they have this borderline personality disorder, might have a problem in their perception and memory and all of this other theoretical conceptual stuff versus the concrete. At different times, at different places, this witness said something different.
Sure. And what the expert testimony would do is provide additional context for why those inconsistencies might be happening. And it would have allowed the jury to credit, to whatever extent they wanted to, an expert's testimony explaining how these might just not be mistakes. These might be attributed to a faulty memory. And that, I think, it provides an overall context to the inconsistent statements that the jury wasn't able to hear and that the prosecutor wouldn't have been able to easily explain away. I think sort of going back to the identifications and tying it to the third-party culprit evidence, the third-party culprit evidence is especially important where it points to a person who matched the description of the shooter. And that would have been even more important in the context of an eyewitness identification. And at the time of trial, the jury did not have the benefit of the eyewitness identification science that this court has now held constitutes newly discovered evidence in Gaines and Mercado. And because of this, the jury didn't have the tools to evaluate the reliability of the identifications made by both Miss Annis and Hall. And critically, the jury didn't hear expert evidence that would have allowed them to understand that Annis's claimed familiarity with Mr. Pina didn't insulate her from making a misidentification. So Dr. Franklin testified that true familiarity lies in people who are close friends or family members, and strangers lie at one end of a spectrum. That familiarity lies on a spectrum, and there's this gray area in the middle, and that's where Miss Annis's purported familiarity lies, and that's where errors occur. And this court has recognized that because in the jury instructions, including the ones that were just approved on February 18th, there's a specific instruction that asks the jury to consider whether or not the witness is a family member, a close friend, or a longtime acquaintance. And there's a long footnote 11, which cites to a string cite of research that tracks the testimony of Dr. Franklin with regards to this issue of familiarity. So in terms of newly available scientific evidence, the jury was deprived of hearing evidence that relates to her claimed familiarity. The Commonwealth continues to use her purported familiarity as a shield to any attack on the identification evidence, but that shield is not impenetrable, and that's the problem here. The jury didn't have the tools to understand that. The jury didn't hear expert testimony explaining that both Annis and Hall's initial non-identifications, and I do consider Hall's 6 out of 10 or 60% a non-identification, and this court has said that that type of unequivocal identification is unreliable inherently, were diagnostic of innocence. The court didn't hear expert testimony explaining how the numerous estimator variables that increase the risk of misidentification by both Hall and Annis affected the reliability of her identifications. And there's no question that this would have been a real factor in the jury's deliberations, especially where there are already numerous inconsistencies in the eyewitness testimony.
But that focuses on this one piece, and I go back to why this case is so hard. Judge Krupp is making this cumulative kind of analysis under Rule 30. And, you know, you heard some of the limitations, particularly with the impeachment evidence and the jurisprudence that we have that Justice Gaziano went through with you. So what are the limits on this? What are the limits on kind of relief under Rule 30 in this kind of cumulative context? I mean, you're always going to have a bunch of these factors. And so what's going to be the limiting principle here to the finality of decisions and verdicts?
Well, this court has been very clear in cases like Brescia, Epps, Rosario, Ellis, that when there's this confluence of factors that considered together make it clear that justice may not have been done, that specific standards have to yield to the underlying principle of Rule 30, which is the touchstone must be to do justice. And in this case, where we have a third-party culprit issue, where we have new eyewitness identification science, where we have expert testimony indicating that there may have been psychiatric and substance use diagnoses about one of the key witnesses that could have provided important context to her testimony, and where there's favorable DNA results, All of those things together create a perfect storm of injustice here, and I think very firmly demonstrate that it was not an abuse of discretion for Judge Krupp to find that justice may not have been done in this case.